This is a pretty interesting module. This is the module on administrative law, and unfortunately today businesses are really bound up with dealing with the increasing burden of more and more and more regulations. And so we're going to talk initially about administrative agencies in general, and then we're going to talk about some specific areas like securities law, antitrust law, consumer law, and environmental law. So that's our target for tonight. And the nice thing is we don't have a quiz on this material. This will be on the final exam as front and center. So if I feel like I need a little more time, I can kind of borrow a little bit more time in the next Tuesday night. But we'll see how far we get tonight. So there's a lot of interesting topics. Again, very relevant stuff. One of the neat things, again, about this type of class is that in the short term, many of you are just consumers. You don't own your own business, or you may not be a captain of industry yet. So the relevance on the business side is still coming, but it will be relevant to you, hopefully, as consumers, to know a little bit more about what's going on out there. And so hopefully it's helpful to you in both your personal lives as well as your business lives. So let's take a look first at general administrative agencies. Is the first administrative agency, Interstate Commerce Commission, is 1887. And why would the Interstate Commerce Commission be the first agency? Why were they so important? What was happening, since y'all remember so vividly, what was happening in 1887?
Reconstruction.
Well, Reconstruction, but that only impacted the South. But there was an aspect of Reconstruction that certainly impacts the United States.
Railroads.
Railroads, absolutely, very good. That's the right answer. Yeah, railroads. So what was happening is you had a system that was not being fairly administered, and the railroads were the big dog. This is before there were trucks and cars. And the United States industrialized very, very rapidly after the Civil War. So we need to make it fair because the railroads are so critical to the success of America. And so basically, if a couple of you walk into the railroad station and say, well, I need to ship a train load of cotton, they might say, well, I like this, he's a good guy, he speaks my language, and so I'm going to give him, 25 cents a bale to use my railroad car to ship my cotton from Texas to St. Louis. On the other hand, I don't like you at all, and so it's going to be 75 cents a bale for you, making it uneconomic for you to move your crop. And they may have ulterior motives like forcing you to sell locally. They'll send somebody over to buy your crop locally, and then they'll ship it and pocket the profit. So the idea was, because the railroads were so critical to the success of America, they went in and set rates for everything. So you had to have a rate for, and all this is before computers, folks. Before modern typewriters, before computers. I mean, it's a pretty amazing system. But you would have to have a rate for every commodity that would be moved on a railroad and every distance for that commodity.
Is that why the commodity trade is in Chicago? Because that's what I'm, or kind of to a degree still is, the railroad hub.
Very likely. Certainly the railroads follow. And for instance, a bit of trivia here in Texas is, I don't know how many of you have ever been to Jefferson, Texas. It's in far southeast Texas. It's northeast Texas above Marshall, Texas. And you're not far from Texarkana, the corner of the state up there. And believe it or not, Jefferson, Texas was a seaport in olden times, and apparently was caused by blockages in the river, made the river high enough that ships could get all the way from New Orleans, from the Gulf, all the way up to Jefferson, Texas, quite a height. And they turned down the railroad. That was the new idea coming into town. And the railroad was being extended to Texas. I'll tie that to another piece of history in a second here. So what was happening is, Jefferson says, well, we got a seaport. We don't need those stinking railroads. It's the seaport, about the only thing that was earlier than the railroads was water transportation. Ocean, of course. So they turn down the railroad. The railroad goes to an unknown place called Fort Worth. Fort Worth is created because the railroads go to Fort Worth, but Jefferson turns them down. Well, tie that piece together with the fact that many of you are aware that in a couple months here we're going to have the trail riders, and the trail riders replicate something that happened during this period of time after the Civil War, but until the railroads got to Fort Worth. And what they would do is they would drive the cattle from Texas up to the nearest railroad point, which was St. Louis, which has become famous for steaks and stuff like that. And that's because the railroads were there, and then the beef would be slaughtered there, cut into meat, and then shipped further north. And so the big trail rides were eliminated by bringing the railroad to the cattle. So, and of course, we developed the industry a little bit more sophisticated and began to grow different types of cattle. And so it's a pretty interesting situation. But anyway, Jefferson still hanging in there. Army Corps of Engineers, there's a big log jam on the river serving Jefferson. Army Corps of Engineers say, we've got a fix for this, we've got dynamite. So the Army Corps of Engineers goes out, blows up the log jam in the river. And we're not talking a few logs, we're talking a wall of logs that is preventing the river from flowing. So they do too good a job, and it drains the river. So there's a trickle now where there once was a big river that would support ocean-going ships, and once the log jam was gone, all of the log jam was gone and all that. So Jefferson is a town of, I guess, 7,000 or 8,000 people today, and Fort Worth, of course, part of the Dallas-Fort Worth Metroplex with a big railroad yard. And so you want to see where the historic starting point was, is the infamous Billy Bob's nightclub, or Honky Tonk. That's right at the stockyards. That's where the stockyards are there, again, because that was the railroad terminus when it was extended from St. Louis. But anyway, ICC, very important to the history of the United States, and an example of why we had an administrative agency. Connecting this up a little bit more, we're going to talk about antitrust in a little bit. 1890, just 3 years later, we passed the Sherman Antitrust Act. A few very sharp entrepreneurs get ahead of the game. Carnegie and Rockefeller and Jay Gould and John Pierpont Morgan. And these people figure out how to be the best and most dominant in their industry, and to the exclusion of everybody else. And they hang out together. So it's like, again, kind of like the railroad example, is you're friends with Andrew Carnegie, so he's going to sell you steel for 25 cents a pound. He doesn't like you. It's like, nope, you can't have any steel at all. Funny how that works, So everybody's a buddy. Carnegie's doing the steel, and Vanderbilt's running the railroads, and Gould's running other business operations, and it's amazing how this stuff sorts out in a very big hurry. And so, David, I want you to keep the historical perspectives in mind as how this stuff started in place. We'll tie some more of that together to help you remember what we're talking about and how it applies. Administrative agencies have multiple purposes, and basically what we're doing here is they are the experts. So Congress has to pass a law that's called enabling legislation. Classic example we're going to talk about in a little bit is the Environmental Protection Act of 1970. That is an enabling legislation that creates the Environmental Protection Agency, the EPA, but it also says, this is what we want you to do, EPA. But then it's up to the EPA to say, well, what is clean air? Well, clean air is so many parts of particulate per million, ppm. Who decides that number? Congress doesn't have that expertise. Administrative agencies get to do that. Plus, they also serve as experts to both consumers and industry. So if you have questions, if you need information, they can do that. What we're concerned about as business people is enforcement, is that if they come in and investigate our organization for labor law violations, safety violations, environmental issues and all that, unfortunately, not only do they serve as the enforcement arm, but they also serve as the judiciary arm to a certain extent. And if you're unhappy with what happens there, then you have to incur the expense of going to court, which is a big expense. So kind of a difficult deal. So something to think about as you look at the next few slides here. We mentioned the ICC. Another area of complete control is the NRC, mentioned in the second bullet, Nuclear Regulatory Commission, which is charged with the safety of all our nuclear power plants and other applications for civilian, not for for weapons, but for civilian things. EEOC is not a unique agency. Many states have state agencies, and in fact, certain cities have their own city equal opportunity agencies, but probably the best known is the Equal Employment Opportunity Commission. We mentioned already the first bullet is how we get the administrative agencies, and enabling legislation sets it up and says, well, we're going to do this, we want you guys to go do that. And then the next step, though, is how do you get there from here? And the key dominant piece of legislation in this area is the Administrative Procedures Act of 1946, or we call the APA. And this is the controlling piece of legislation in terms of the agency is created by the enabling legislation. It acts within that. How do they go about creating this maze and thousands of pages of regulations defined under the American Administrative Procedures Act? We have two basic kinds of agencies. We have cabinet departments. This is very hot today. All the news seems to be centered on who's going to get what appointments in the mystery Trump cabinet because well, he's never held office before, so people really don't know what's going on. He seems, yeah, I think he's got a pretty clear idea, but it's kind of interesting to see what's going on out there because there's a really interesting book about Lincoln on leadership. Everybody familiar with that? Have you had a leadership class that used it? It's a paper book, but it's a bestseller. And what it talks about is that when Lincoln was elected, he was not particularly well known nationally. Of course, this was before you had Twitter and television and radio and everything else. What's that? Yes, that's right. So, it's just, he had to come up with somehow to communicate, but he managed in his own time to be kind of a surprise and got elected over some people who were much better speakers, better looking people, and people that had more credentials in Washington, D.C. So an interesting selection as president, and of course on the eve of his being elected, the South succeeds to add insult to injury to his election. But in any event, what Lincoln did when he assembled his cabinet is he took the people who were some of his most vociferous critics and made them members of his cabinet, which is contrary to the popular conception that we see a lot of today, where you reward your buddies and your supporters by giving them key cushy positions in Washington. So the last few days have been very interesting because Mitt Romney and Ted Cruz and a pretty good handful of people have been over there that you were not expecting to be hanging out with Trump and his buddies at Trump Towers in New York City. So it's very, very interesting to look at what has happened. In any event, cabinet agencies are executive branch agencies. They report through the president. Includes the Department of Justice, the FBI, and so forth. But we also have independent agencies. The Securities Exchange Commission is an independent agency. Something you may find interesting, the Department of Labor is an executive agency, But the National Labor Relations Board, which controls unions, is an independent agency, which makes no sense to me, and I do employment law. That one part of it would be through a cabinet agency, and they park the other one someplace else. But it allows you to spend more money and employ more people uselessly. So anyway, kind of interesting thing. So the agencies, of course, make rules, they enforce the rules, and they adjudicate rules. Doesn't that sound like judge and jury? Yes, popular concern about administrative agencies. Okay, what we're focused on in the early part of this chapter is talking about how do we get rules. And then you're going to find out all of this is kind of funky anyway because you can get around it. But this is how it's supposed to work. Is the first step here, is you're going to start off with rules, and you got two types. You have legislative rules that provide guidance for the agency and give the agency some specific direction. And then the legislative rules are developed by the agency to say, oh, okay, well, we're going to have clean air. Here's how we have clean air. Here's how we define it. So basic starting point, published in the Federal Register. Federal Register, published every day, hundreds and hundreds of pages every single day. It amounts to just incredible stacks when it was all done manually, and your lobbyists and your people in Washington, D.C. would be responsible for keeping track and reading all these federal rules. Much easier today because so much of it's electronic. You can scan for keywords and do things that we all know how to do. Even us technically challenged people can figure out how to do this stuff. Makes tracking this a lot easier, but again, we generate an enormous amount of paper figuratively or literally in this situation. Now, how your lobbying organizations work, it is their responsibility to monitor this. So that, for instance, we used to use the American Trucking Association, ATA, as an example. I visited them in Washington, D.C. some years back. At that time, they were in Alexandria on the Washington Beltway. They were in a nice office building, had about 50 employees. And they are supported by the big trucking companies like Schneider, McLean, provide large sums of money because they not only act at the federal level, but they also act at the state level. Now, a bit of a disclaimer. Tonight, we are strictly talking about federal agencies. But keep in mind that, again, there are many state agencies and even in some cases local agencies that also perform some of these services. Now, sometimes there's a deferral, like California has Cal OSHA, and Cal OSHA is regarded as a substitute agency, that they reach a certain level where instead of having both federal OSHA and Cal OSHA in California, they have just Cal OSHA because it's been recognized as an appropriate substitute for a federal agency operating in that state. So it depends on where you are, how different agencies are regarded. You don't have to have a state agency if you want. You can rely on the federal government. So it varies from state to state, and in terms of the amount of information that's being developed and how it's being administered. Texas, for many years, had a commission for employment of the handicapped. Of course, we don't use the term handicapped today, we use the term disabled. But that committee was around for many, many years. Texas was one of the early states to recognize the importance of advancing people with disabilities, to try and help them return to the workforce and not be at home, and give them some respect and some opportunity, and also reduce the drag on the economy from people who are unable to work or not been able to work. So kind of interesting developments. But that morphed into the Texas Commission on Human Rights, and if you file an equal employment opportunity complaint here in Texas, you have the option to check a box and say, well, we're at the EEOC, but I also want to file with the Texas Commission also. And so both agencies will take a look at it sometimes, although there's a deferral arrangement, usually on disability, because of Texas's long history in that area. Disability claims are often handled by the state agency as opposed to the feds. The feds are about a year behind in investigating So a pretty interesting situation. So first thing we do is we publish the rule in the Federal Register. Mandatory meeting provided for with recorded testimony. Now this is how the lobbyists get together. So ATA sees a rule. It says, well, we're going to require trucks on the federal highway system to be 10 feet shorter, just to pick some hypothetical example. Well, that's going to have a massive impact on the trucking industry. So the ATA people that are paying attention flag this. They let the big customer members of their group know what's going on. They develop a strategy. They may have somebody who's a key person at Schneider or McLean or some of these companies. They will arrange for them to be key witnesses. They'll put themselves on the list and say, hey, we need to have a chance to talk during the live hearing on this proposed regulation, and they'll bring these people in. Now, again, you may have people on the other side. Remember, this is not necessarily it's not a one-way deal. So you may have an environmentalist come in and say, well, we think, you know, it would be better for the environment if we have shorter trucks. You might even have the American Automobile Association come in and say, for us as consumers driving regular personal vehicles, it would be safer for us if the trucks were shorter. So again, a lot of different forces get in play depending on the nature of the particular proposed rule, the industry's impacted and all that. So that's the next step, is usually a big public hearing to consider what happens. The meeting is then summarized, and then there's a decision made as to a final rule. Now, this is a highly simplified example of what happens. So you may end up going through the system in a lot more complexity. Now, one of the things that makes businesses normally nervous, is that we're not sure whether they always do the procedure we just described. In a perfect world, that's what they do. But suppose they say, oh, this isn't very serious, we'll just rely on informal rulemaking. So the question is, how do we decide whether it should be subjected to full review or to informal rulemaking? And this is an area of controversy as to where things get handled in a different manner. So they still have to publish it, they still have to run it 30 days, but this is where you end up with the lobbying organizations, again, say ATA, American Trucking Association, having to run into court and file a suit because something has happened without going through the longer procedure. So you can see how that could set up some controversy.
So can you file a lawsuit and I just don't know the process before the law has passed?
I'm not sure. I think you have to have it in place. It has to be, it has to have at least 30 days. So after it's in place, but before the 30 days have passed when it can be effective, that's when you file a lawsuit to stop it from being effective. And I'm trying to think of a vivid example of that. I can't think of one right offhand. But what happens is that the courts a lot of times will say, well, you didn't follow the procedure, there's not enough. Concierge service here. Of course, she's trying to put her feet up on a chair, so I put some chair closer to her. I don't care if you put your feet up. This woman's got twins at home, twin children at home.
It's all in the video now.
How old are the twins this week? 11 months. Gosh, they're both running around already. 2-footed or 4 or 2? 2 feet or 4 feet?
Depends.
Or they're crawling off or pretty fast. Yeah. Lady needs to put her feet up. This is her respite. The rest of you is suffering here. You know, it's like, God, I got to go to class. She's like, yes, I've got to go to class.
Sorry.
Hybrid rulemaking, a combination of informal and formal. Gosh, what a hard concept that is. Yeah. And I'm still not sure what hybrid means, other than they do whatever they feel like Okay, enforcement. This is where many of us as business people are not able, because we're not part of big businesses that play in the big sandbox in Washington, we just take what happens, either because it went through informal rulemaking and it happened anyway, or we're just small folks, or we got into the business now and we inherit what's already in place. An example I often use is dry clean. I remember I've been an executive for many years. I unfortunately have to be a regular customer of dry cleaners for my suits, and you would go in there, and I remember when I was younger, you would go into dry cleaners and the chemical odor would just like hit you from the, you'd get close to the door and it would be like this wall of fumes, especially, obviously not all dry cleaners do the cleaning on site, but we're talking about the ones that clean the clothes on site, and it was really very nasty. And it's interesting because there's been some significant developments in terms of the chemicals that are used and also environmental exposure for your employees. So if you notice today, in fact I ran through the dry cleaner, dropped off some clothes dry cleaners this morning and did not get knocked off my feet, and it is a dry cleaner where they do them on site. So there were people in there working with the machines and everything, and I wouldn't say it smelled great in there. It actually didn't smell bad. We had a pretty good breeze this morning, so they had the front door open, and who in Houston leaves the front door open, right? I mean, we all got the air conditioning, got to keep that door closed. But anyway, it was early this morning. So the point is that if we decide to go in a dry cleaning business, keep in mind again, we're talking about federal rules, but we're going to be affected by state rules and by local rules if we establish a retail business like a dry cleaner. But where we're focused in today is OSHA regulations that may say you cannot have certain chemicals even in your business because they're too toxic for humans. So there's certain types of chemicals may not be able to be used in a dry cleaners today. They may have certain rules on how different exposures are measured and things like that. So a lot of different rules come in at different levels, and that's what we're talking about. And if you do not follow those rules, then you're confronted with some significant issues. And in our employment chapters, when we talk about that briefly, in our employment chapters, we talk about the fact that safety is not optional, that you're subject to different safety rules, either specific rules for your industry or just general safety rules. Speaking of safety, everybody's heard what horrible thing happened this morning in Nashville, Tennessee. I think it's Nashville.
Yeah.
A school bus. Oh, and it's even worse. It was an optional school day. It was an optional school day, and this bus driver wrecked the school bus. I think there were 37 children on the bus. Last I heard, 5 killed, 12 in the hospital, 6 of them very badly hurt. What a terrible Thanksgiving week. And so we have these situations. You're going to have an NTSB, National Transportation Safety Board, was already over there investigating. You're going to have, it's a workplace incident, so you may have OSHA involved. The driver was not killed, so you don't have a mandatory fatality reporting. And as far as I know, he wasn't seriously hurt, which is rather amazing, because usually in a bus or truck collision, the driver is most often the person killed. But the accident itself, very odd accident. The bus is literally wrapped around the tree. Have you heard that term before? If you'll see the pictures on the news tonight, it is wrapped around the tree. And it's like curved front with back, and then the tree's kind of in the middle.
They arrested the driver, right?
Yes, they did. And they're saying that he was driving at a very high rate of speed. The early report said he did it deliberately. I'm not sure if he did it. It's such a horrible thing to think of that somebody would do it deliberately, that I find it more likely that he decided to hot dog the bus a little bit and lost control of it. I think that is a more plausible theory, but it's still reckless driving and probably going to be tapped with 5 or 6 counts of involuntary or voluntary manslaughter. So, right. But very sad set of circumstances. But that's why we have regulations, and some of those regulations include School buses. School buses used to not have seat belts. School buses are required to have seat belts today. But that was relatively recent. Until relatively recently, school buses didn't have seat belts. Who would have thunk? You know, with federal rules that require seat belts. I remember cars that didn't come with seat belts.
It's only in the state, Texas, New York, Texas, and like 3 other states require seatbelts. No other states
required. You were saying required to use the seatbelt. I'm going back much further. I remember our family cars when I was a youngster did not come with seatbelts. In fact, I can tell you, my dad bought a 1963 Rambler station wagon. And I remember going to this do-it-yourself auto shop and the car being up on the jack, up on the lift, and my dad actually installing seat belts and bolting them through the floorboard of the car because the 1963 Rambler didn't come with seat belts. Seat belts became standard about 1964, 65, shortly after the Rambler was produced, but the cars before that did not have seat belts. And then that was strictly lap belts, strictly here, which of course allowed your upper torso to smack against the steering wheel. A lot of changes in automobiles, speaking of different types of regulations, happened with Ralph Nader published a book to attack the Chevrolet Corvair, which was an interesting car. It was the only rear engine powered mass-produced American car. Had many, many innovative features, and Nader decided to go after it. And there were some good things that came out of it. One of them was that some of you, if you're familiar with older cars, had huge metal dashboards. So the padded dashboard was a result of Nader's criticism of cars. The break-off steering wheel, many drivers were impaled by the steering wheel.
It was a solid steel.
It was a solid steel pipe that went to the front of the vehicle. So if the vehicle hit frontward, the pipe was driven directly into the chest of the driver. It was just a horrible design. And so now the steering wheel is done in several pieces so that it actually collapses differently. So, but very interesting. There's some different everything's on YouTube today. You can go and watch some YouTubes about one of the ones that I've shown in some of my ethics classes. Show kind of some of the Corvair testing, and they would roll the car over and do strange stuff and all that. But like I said, padded dashboards, collapsing steering columns, side support for the vehicles, a lot of different improvements. And of course, Nader probably couldn't even have conceptualized airbags. So airbags, of course, are pretty standard today. So a lot of different things. Speaking of, again, federal agencies, Federal Trade Commission is in a big dispute with General Motors. The big news today, 2.5 million cars are supposed to be recalled by General Motors by order of the government because they have Takata air inflator triggers, and so they're saying all those inflators need to be replaced. And so it's a huge number of vehicles. What's interesting is General Motors is actually pushing back and saying that just because they were made by Takata, which was involved in the Honda and Toyota recalls, doesn't mean that these are also defective, and so they're arguing that they're not defective. So it's kind of interesting. But again, these are the administrative agencies that we're talking about here. This is exactly the kinds of things that we're talking about. So some of them have direct consumer impact. But again, depends. You can be on both sides of the case, right? You might be a consumer who owns an automobile, but you might work for an automobile company or a company that makes components for an automobile, right? So you could be on either end of this argument, or both ends for that matter. Now, you may recall when we talked in our employment chapter, we talked about whether you're going to force OSHA to get a subpoena. So the Occupational Safety and Health Administration shows up on your door, says, hi, we're here to inspect your premises. Now, again, there's two reasons they can do that. One, routine inspection. Two, because they're investigating a specific complaint, like a school bus accident or some horrible thing happens in your manufacturing plant. So with that going on, people have a right to have some involvement in the situation. And the big debate we get into is, with business people, is do you insist on the OSHA person getting a subpoena, or do you say, sure, come on in? And the balancing act is, do you want to aggravate them so that by the time they get in the door, they're mad at you because they're going to get the subpoena? So the question is just timing. If you keep things reasonably clean in your plan, you probably just want to let them in there. The way I work with my clients is we just tell them to call me, and I walk them through a very brief exercise. So we don't let people, they don't just say, oh yeah, sure, come on in. But what they do is they interact with them, they get their credentials, and they call me, and we talk about it, and then usually we let them in without requiring a subpoena.
Just to verify that they're with the agency they say they're with, is that?
Well, that's part of it, but actually it's a little bit different than that. OSHA does not have all of the employees it needs to conduct all of its investigations. So they kind of deputize local people. So say that you're a manufacturing plant and you have some proprietary production techniques. You don't want the competitor down the road to come in as a designated OSHA inspector to come in and go through your plant and maybe pick up some stuff that gives you a competitive advantage, and they take it away for free. So,
How do they regulate that?
well, this is why you have to be sharp about it, because see, knowing what you just heard,
Yeah.
then you know that one of the questions that we ask when I'm get the call from the client saying, hey, OSHA's here, is I want to know what their credentials are, because are they an OSHA employee, in which case I'm okay, or are they an employee of a competitor designated to do the investigation for OSHA, in which case we probably won't let them in. We'll say, you don't need a subpoena, but you have to send an OSHA investigator. We won't let a competitor in our shop.
Gotcha. So their credentials would state whether they're direct
Yes.
or direct employee
Yes.
or a designated.
Exactly. Yeah, the credentials, they're going to have a badge, and the badge is going to tell you if they're a regular employee or they're designated. And so,
Contractor, is that what it is?
contractor, exactly, they would be contractors to OSHA. Now, again, it may be the person is from a non-competing business, or just a professional safety inspector who's under contract to OSHA, in which case it's probably not much argument. So it just depends. We just want people to be aware of being careful, not just let anybody in and all that. But again, this ties in what we're talking about here with the investigative function. That's why I brought it up as an example. And also subpoenas. Again, most of the time, subpoenas are going to be granted. Now, here's where it makes a difference. Again, talking about OSHA for another minute or two. With OSHA, they have free run of the plant if they're doing an open inspection. But again, most OSHA inspections are because of an incident report. If they're coming out to investigate an incident, they're only authorized to go to the area involved in the incident. So knowing why they're there defines what they can go do. Yeah. And so, you know, again, you want to minimize the harm or the potential harm. Keep in mind that businesses are under a different constitutional standard. As individuals, again, you have probable cause for a search warrant, you have Fifth Amendment protection, stuff like that. Most of that does not apply to businesses. Businesses do have a right to request Fourth Amendment search and seizure, but reasonable cause is just, hey, it's your turn to get inspected. We feel like doing an inspection. So it's a much lower standard than if the police want to search your home, for instance. So keep that in mind.
So, just a question, and that's an
Yes, sir.
example. So, let's say a business is getting inspected by OSHA because of something happened and they're investigating what happened, right? So, and let's say there's 2 lines of production.
Yes.
That accident happened in the first line, so they go and investigate that. But on the second line, there's something going on that might be not, it might be against OSHA. and
Like non-compliant.
non-compliant with OSHA on the second line, whatever they're doing on the second line. So, since they're only investigating one part, or
It
because of.
shouldn't be relevant, it shouldn't be within their scope, is what you're
Yeah,
saying.
so basically, is that what it is? I mean,
Yes,
basically,
you can.
they protect the business, if they're doing something wrong on the other operation that they
Well,
cannot be.
I can tell you, if they're in the plant for an incident, you can steer them to a particular area and say, this is the area that you will be allowed to inspect.
Mhm.
However, they're not blind. If you have screaming violations, they could do two things. They could observe it now and report it now, or they could say, boy, we better come back and do a full investigation. And again, they don't need a reason. They don't have to say, well, we saw something bad last week in another part of the plant on our way to the incident. They can just come back, or they can just write it up. So they have a lot of flexibility on that. And that's why you want to have some understanding of where they're going, and not have them end up traipsing through the whole plant. So you may want to, like if the option is walking around versus putting them in a golf cart. A lot of business and industrial plants have golf carts, like we have here at St. Thomas, move people around. You may want to give them the deluxe treatment, take them from the front gate directly to the incident in the quickest route possible. Because some people may say, well, we're really not happy that they're there, let them walk. Yeah, let them walk may not be your best option, right?
Yeah.
So that's just the reason I want you to think through what you're dealing with here. Now, this is one of the more controversial areas of the administrative agencies, and this is adjudication. Remember, we talk about the fact that in the United States we have a separate judiciary. So we have the lawmakers in Congress, and then we have the federal courts over here that do the enforcement. Well, administrative agencies, they're combined. And in fact, I've been in front of administrative law judges before, and I felt like they were pretty much against us before we ever got started. They're employees of the agency.
So what is the oversight of the whole checks and balances system is supposed to be? Congress makes the laws, the Supreme Court makes sure that they're constitutional.
Yes.
Well, if they create an agency that's quasi both, where's the oversight?
Exactly. Remember we talked at the beginning of the course, we talked about some of the review chapters that we didn't cover specifically in class, and we said the situation is with this situation is we have the legislative branch, Congress and the Senate, we have the executive branch, the President and Cabinet, and then we have the court system that is the adjudicatory branch. Where do administrative agencies come in? Well, the administrative agency is like this giant fourth branch of the government that doesn't really get explained very well, and creates a lot of havoc and a lot of pressure on businesses and individuals in some cases. So, and again, this is not just, we're just talking about federal agencies. Again, there's a stack, and you're in business on the bottom with the pressure of all these organizations on top of it. And sometimes it's county, it's not just municipal, it's county and municipal at the local level. So you can face a lot of different challenges, no question about it. Formal adjudication, this is in front of administrative law judge. These are well-compensated people. I think they pay around $90,000 a year, and they generally are in central locations, and then if there are hearings in more outlying areas, I remember I did an ALJ hearing here in Houston, and the ALJ came in from North Carolina for some reason, and they travel around and render decisions. Like I said, I did not feel that they were independent in the least. That they were very much rigged to favor the administrative agency. The answer to your question is, if you feel like you've got the raw deal from the administrative agency, then you can go to court. The problem with going to court is it's very expensive. It's very time-consuming, expensive, and so the clients have to make a business decision about, well, do you want to fight about this, or do you want to just pay and move on? A real odd case that we handled in OSHA some years ago is I had a surveying company here in Houston, and something weird happened. This guy was mad because he had to stand in a, as you know, in rural areas, we don't have sewers and finished streets. We have drainage ditches to keep the water off the highway. Well, he was doing some surveying for in a rural area, and he had to stand in the drainage ditch to do that, and he complained because his feet got wet, despite the fact that he was issued boots. So, you know, so he's just being a wuss, basically. So he files an OSHA complaint because he had to stand in the water in his boots. And so OSHA investigates and does not uphold the complaint, part one. Part two, however, was they said, oh, by the way, where's the nearest hospital? We're like, we don't know where the hospital is. And it turns out if you are more than X distance, like a mile or 2 miles from a place for first aid or a hospital, this was a rural area, then one of the members of your team must be trained in first aid. Fine was $500. So I said to the client, you know, the problem is that this is ridiculous. I mean, this Houston, this is an urbanized area. Clearly, he wasn't that far if he had needed some type of medical assistance, and he didn't need medical assistance at all. He's just been a wuss. So what happened is the client said, I'll go ahead and just train everybody who goes out on a crew in first aid. That way, there's at least one person on every crew because everybody will be trained in first aid, and I'll pay the $500 fine versus fighting about it and spending thousands of dollars in legal fees and running the risk of still losing the case. So that was how the client decided to resolve it. So not everybody fights because sometimes it's just not an economical decision. Now, the risk that he runs is that was many years ago. I don't know, the business has changed hands since then. I don't know if the current operators of the business are paying attention to what they're doing and if they are still training everybody in first. In other words, you train everybody in first aid 12, 13 years ago with normal turnover, maybe you're down to 10 or 20% of that people is still there. What about the rest of the people? Did you think to get them first aid trained? See, that's the type of thing we're concerned about when you accede to a compliance demand like that. So that's the reason there's an issue. And then we just talked about this a minute ago. You can go to court, but that's, again, time-consuming and expensive. Now, this is one of the more interesting aspects of this. You may remember in the early part of the course we talked about standing being an important part of litigation. You have to have standing, meaning you have to have a dog in the fight. You have to have some direct impact on you in order to challenge this. So as a, for instance, when the Affordable Care Act, ACA, was first passed, a number of states went to court and said, we don't want this to happen. Some other people went to court to stop it from happening. Some of those plaintiffs were thrown out of court saying, you don't have a dog in the fight. You're not really involved. You do not have standing is the legal term for that. Similarly, in these administrative agencies, when they do certain things, people get upset and say, oh, that's going to be a big heartache for business. This is going to be difficult. You have to have somebody to be who's actually impacted. So for instance, you're the American Trucking Association. You're upset about a new rule on trucks. You don't file the suit on behalf of ATA. You file it on behalf of one of your member companies, like, you know, big companies like Schneider and McLean, and then they become your token plaintiff because they do have standing. They are indeed directly impacted by a law that changes trucking or the use of trucks. So that's what we're talking about standing, and that is a big deal. Courts have a couple options. Now, just so you know, it is not easy to win a case. It is not easy to win a case where an administrative agency has ruled against you because the courts generally use a deferral, a standard of deferring to the administrative agency. In other words, the agency are supposed to be the experts, and the courts accept that. So unless the thing is pretty egregious, your chances as a business person of overturning that case is not that high, just so you're sensitive to that. Now, sometimes if it's really outrageous, the court will implement a de novo review. Start from the beginning, present all the evidence again, because it sounds like things were not done properly. So that's where we kind of look for that type of situation. If we think it's really out there, we have a better chance of going to court and fighting it. But again, I want to sensitize you to the fact that, again, as individual companies, it's not likely that we have the resources to spend hundreds of thousands of dollars to take a complaint through the federal court system to the United States Supreme Court. We're not going to want to do that. So because of that, usually it's going to be an agency like, lobbyists for the trucking or the lumber or the coal industry or something like that. That's why it's like that, because of the high cost. You need to have a collective kitty to spend the money to prosecute these things. When you see a case that's gotten the U.S. Supreme Court, you figure that each side, well, of course, many times the federal government on one side, and of course they don't care because they're spending OPM, other people's money. But on the business side, you're looking at $500,000 to $1 million in legal fees alone, and that's if you win.
This might be kind of a remedial question, but how does the IRS classify?
Well, the IRS is part of the Department of Treasury. It's an administrative agency
So,
through the executive function.
When they change their rules, does that get published in the Federal Register?
Yes.
Okay. And there's still public comments, or?
Again, I think they do a lot of informal stuff, so you kind of get in there after the fact. What's interesting about the IRS is that, unlike ALJs, they have tax court. And so here's your decision to make. If you don't want to pay the tax, you can go to tax court, but again, that's in-house to the Department of Treasury. If you're willing to pay the tax, you can pay the tax and then go to regular federal court to complain about it. So you have to decide which way you want to go to fight about it, because most of us don't want to pay the tax to start with, but then that puts us in a disadvantage because we're in the in-house court instead of going in the regular federal court system.
So I always understood that you had to pay the tax first in any case, but so if you pay it first, you can go to federal court.
That's my understanding.
Okay.
That's my understanding. Yeah.
You're the lawyer.
Well, but I also don't litigate tax cases, just so you know. So it's changed since I learned it, figured it out. And now, this is one of the more abused things out there. This is something that is a good idea gone wrong. Gosh, that would never happen in our federal government, right? FOIA, Freedom of Information Act. Freedom of Information Act was passed all the way back 40 years ago, and it is designed to give transparency to government, to allow the public and the press to ask to see what's happening behind the curtain. And so what has happened, though, is that there's very little penalty for ignoring FOIA. This is supposed to happen in a very brief period of time. Now, by the way, you can be charged for it. If it costs the agency to produce 1,000 pages of documents, they can charge you 50 cents a page or whatever it is. But usually this is the New York Times or the Wall Street Journal or the Washington Post asking for the data, and they're certainly willing to pony up the money for the cost of production. So this is a big deal. And so what happens is that the normal FOIA request is delayed 2 years, largely making it almost unusable at that point because it's being produced so far after when you wanted to see it. So it is a very unreasonable situation that exists today, and certainly a perversion of the intent of the Freedom of Information Act, again, said FOIA. So one of the things to keep in mind is that the whole business over the last year about the Hillary Clinton emails, that is the result of a FOIA request. And what they did is they FOIA'd it. Somehow they knew they were out there. So they FOIA'd the emails, and nothing happened. So, and I forget if it was New York Times or Washington Post or both, but went after them once they found out they were there. And there's some weird thing happened, like there was a congressional investigation and somebody testifies, and the people who are covering it realize, oh, well, if they're talking about private server and all this, then there must be emails. Well, they didn't go and say, we want to see 33,000 emails. They said, we know there's emails. We want those emails that were discussed in that congressional testimony. That's what the FOIA request would look like. Again, government agency dragging its feet, Secretary of State's office, go to court and say, no, 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 you produce them now. And that's why you got those redacted reports, because they're not required to release confidential information. And remember, a bit of trivia associated with that is that some of the reports were so sensitive, there's a dozen that could not be redacted. They were so sensitive, there was nothing they could produce. So they couldn't even redact them, it would have all been black ink. So it's kind of an interesting process, but just, you know, that's a very vivid example of where FOIA was utilized, but again, it wasn't because one of you in this room said, hey, I'd like to see those emails. It doesn't work that way. And it should. We should all, again, as long as we're willing to pay the cost of production. And again, that's a sensitive issue because you can understand why it would be big newspapers and operations like that to get in there and help the public find out about this stuff. So it's kind of an interesting development there. You are not allowed to produce personnel records and other private information. Social Security numbers of employees is a big concern. And this goes through the whole court system, by the way. Even our local courts have rules today protecting sensitive personal information in filings with the court. Because when filings with the court are publicly available, today there's very strict rules on what can be produced. For instance, you know, people get divorced. Divorce documents have bank accounts, and Social Security numbers, and driver's licenses. So there's rules that protect a lot of that information. So basically you end up with a redacted document that's available to the public, but then the other information is provided behind the screen under some specific rules. Sunshine Act, public access to meetings. This again is echoed down the system. And so personnel matters don't have to be discussed in public. Highly confidential issues do not have to be discussed in public. But basically anything of public interest that doesn't involve those things must be open to the public, and that's Sunshine Act. And many, many states today have Sunshine Acts.